Hey guys,
Hey, how's it going?
welcome to another episode of SG Explained. So today is the 17th of September 2018, and the time now is 7:30. Today we're going to attempt to explain a highly controversial topic.
Yes. And that's the whole point of why we do SG Explained. It's because we want to look at things that are difficult to understand on the onset, but that's exactly why we did this show, and we're going to venture into it. The topic that we're going to do, we're going to be talking about Penal Code 377A and its relation to the LGBT community in Singapore. So some of you may be asking, why do it now? There's been a lot of talk about it in the news.
Yes.
Former ambassador, or rather ambassador at large, Tommy Koh, made this interesting statement on Facebook. He basically said it's time for people to bring it to court, and people have been riled up by it. People have been motivated by it, and we'll talk about exactly what's happening right now. But I think we're gonna take a very different stance on it than what most people do. Instead of going straight into the moral ethics of it, we're actually going to go all the way back.
Yes.
Understand the history, understand the context, and then hopefully from there we'll be able to have a better perspective on exactly what 3778
Most
is.
definitely.
Yeah.
Most definitely. So, I mean, today largely is also because I think was the Indian Penal Code making some adjustments as well, and I think
Right.
that's some attention to the Singapore. The Singapore sentiment as well. So people are also bringing this conversation. But 377A essentially had a lot of conversation quite a number of years back as well.
Yeah.
I think
it's not a topic that Singaporeans are unaware of, right? Like if you want to talk about the few things that are controversial in Singapore, you can list them on your two hands, but we know them, right? And 3778 is definitely one of them.
So today I think also please leave a comment about 377A as well. We really want to hear your views about whether you support or whether you don't support the repeal, or really if you have some information about 377A that we are unable to uncover, and it would be great to also discuss it so that to the benefit of everybody, I suppose.
Yeah.
And because this is live, we get a chance to really answer your questions immediately.
Exactly.
Yeah.
Willie and I we're reserving our own personal opinions. We're going to be as objective as we can, stick to the facts. So even if you have an opinion that you think people on Facebook may not agree with, just share it, and we're gonna deal with all of it.
Yeah, but I suppose this topic is a really highly polarizing topic for most people. You have different stance. I think recently you have, religious bodies were very concerned about the repeal, but you also have largely a lot of people who says that this law should be repealed because it's really quite archaic in nature.
Right.
I think we're hearing both sides of the camp, and I think many people have different views about it. But essentially today we want to find out what exactly is 377A. We were talking about 378, yes. Is it about this? Is it about that? But when somebody asks you, hey, what is 377A? I think this is something that I'm not sure if most people know, but it'd be good to know what exactly we're talking about.
Are we going to tell them what is 377A?
Yeah, of course, we're going to do that. But firstly, I just want to give a little introduction. So anyway, for those of you who don't know, this is actually a passion project for both me and Rovik.
Yeah.
And of course, we do this after working hours, hopefully to better explain what is going around in Singapore. And if you have benefited from it, please leave a comment and just tell us what kind of topics you want to hear in the future so that we can better prepare as well, and really to get you knowledgeable about what's happening in Singapore, something that you can learn in depth.
Exactly.
Yeah. Okay, but first, let's really talk about, do you know what exactly is 377A?
I've heard of what it is, but I don't know exactly what's the legal definition of 377A.
What is your impression of 377A?
So I know it has to do with homosexuality.
Okay.
And I know it specifically has to do with male homosexuality. Does it? If I'm not wrong, I think what I understand it to be is it bans intercourse between two males. Is that it?
I see. So let's really get down to the legal definition of the 377A, so that people really understand what it's all about. All right. So this is the legal definition of 377A. So it goes like this: any male person who, in public or private, commits or abets the commission of, or procures or attempts to procure the commission of, procure the commission by any male persons of any act of gross indecency with another male person shall be punished with imprisonment for a term which may extend to 2 years. So that's 377A.
And the specific thing is an act of gross indecency.
Exactly. Yes. So I think there's a lot of common debate about the fact that 377A is about homosexuality directly. But what I can see from the penal code itself, it really just attempts to talk about really this act of gross indecency and not highlighting a specific area of homosexuality. It could be implied, I'm not sure.
Right.
But it essentially just says that any male person who commits this. Yeah.
It's such a vague and interesting space to have a law.
Right. I suppose there are a few things that comes up from here, which is, for example, what exactly is an act of gross indecency?
I can think of like 20 things, none of which I want to talk about on this podcast. But
maybe for the viewers, if you want to leave a comment about what you think is a gross indecency, please leave it on the comment section. Don't worry, nobody's gonna find out.
Everyone on Facebook will find out, I think. But yeah, give us some examples of what you think gross indecency means or has meant. Because one of the other things that I know about 377A is that the government keeps it pretty clear that they don't actively enforce it necessarily.
Yes. They have made public statements about this as well.
So we wouldn't even know what gross indecency means in terms of the government, because they haven't enforced it that much. I know there have been some cases, but it has been a long time since.
Right. And I think later on we will actually try our best to explore what exactly is this act of gross indecency.
Right.
But first, I think with a section like 377A, it really begs the question, what is 377? Because A sounds like a part of a whole section of 377. But really, let's try to find out what exactly is the history, all right?
Right.
So let's go into the brief recent history about the Penal Code Section 377 and the retention of 377A. So there actually is an existence of a penal code section called 377.
Right. And for our viewers and listeners, I think it's important to preamble by saying this is probably one of the first episodes where we're actually going to go into law. We're going to be having some legal speak. We're going to try to keep it as average Joe as possible, because both of us, Willie and I, are not legally trained. So we don't have a law background. So we're going to try to understand it as much as possible. If you are a lawyer and you are listening or watching, definitely clarify if we make any mistakes.
And of course, join the discussion with us so that people may better understand exactly what they're reading or what exactly they're repealing or accepting as well.
Exactly.
So a little history, all right? So what sparked this debate in the most recent years was actually in November 2003. A police Coast Guard officer named Anis Abdullah was convicted under Section 377 of the Penal Code for having oral sex with a teenage girl. Okay, Mama should have told you, but okay, another thing. But although the act was consensual, the conviction generated much debate in Singapore about whether oral sex should continue to be considered an offense in modern times. So back before November 2003, oral sex was actually an offense.
Right.
Yeah.
And I think it's important to harp on the word consensual here, because it actually, so it is a legal term. It's something that has a lot of weight in law. Consensual means that both parties willingly participate. And exactly. So that means whatever sexual act this was, both people wanted it and did it with full participation.
Exactly.
But still it was illegal.
Exactly. And so oral sex, if found out, is actually an illegal thing before November 2003.
Right.
So this case caused the Ministry of Home Affairs to begin a comprehensive review of the penal code.
Right.
So in September 2007, it took quite a while, right? After 4 years.
Oh, 4 years.
Yeah,
Wow.
exactly. The ministry submitted to Parliament the Penal Code Amendment Bill, which proposed 77 amended provisions and 4 repealed provisions as well. So in 2007, there was actually sort of like a proposal of the 377 law.
Right.
Right.
And this was 11 years ago.
Yes, exactly.
Okay.
This is almost 11 years ago. So this comes as, I would say, not a very new topic of
Right.
repealing, but I suppose everybody is concerned now of the specific, which is 377A.
Right.
But let's have an idea what exactly is section 377 in the first place.
Okay.
All right. So let's give you is the legal definition of 377. So the legal definition of 377 actually is whoever voluntarily has carnal intercourse against the order of nature with any man, woman, or animal shall be punished with imprisonment for life.
For life.
Yeah. Or with imprisonment for a term which may extend to 10 years, and shall also be liable to fine. What it means is penetration is sufficient. Okay, so this is my understanding is what it means is penetration is sufficient to constitute the carnal intercourse necessary to the offense.
Okay.
Yeah, so it means that this particular section 377 was talking about penetration. It's very, very specific. Just let me highlight. Whoever voluntarily has carnal intercourse against the order of nature with any man. So they termed it as intercourse. So it's a form of penetration, right?
Right.
Yeah. And they're very specific. This was 377.
Right. This sounds also, let me just say, this sounds like something that was written a long, long time ago.
Yes, exactly.
No, I'm talking about like medieval times, long time
mm-hmm.
ago. Not because of exactly what it's saying, but the language. Whoever voluntary has carnal intercourse, it does against the order of nature.
Yes.
What is the order of nature and what is carnal intercourse? This is something I do know from my very, very brief brush with the law. Or rather, my brief brush with legal jargon. That is what I meant.
Yeah,
is that some parts of the law are purposely left ambiguous, so that it is allowed to be deliberated in court, in public sphere, so that society can make evaluations based on a case-to-case basis. So I can appreciate that, but this seems not useful in its ambiguity.
Right. But this would actually lay certain understanding of the differences between the 377A Penal Code as well as the 377A Penal Code.
Right.
Could you already see the differences? One was talking about carnal intercourse, and the other one was describing about gross indecency.
Right.
Yeah. So these were two very specific areas that actually existed within the entire legal framework as well. So I just want to point to this particular thing. Yeah. So of course, this definition, and of course, was later on repealed and changed. You mentioned that this was, of course, something that was probably very historical. Sounds really old English, I suppose.
Right.
We're going to get into that later as well about the history of how this entire 377 was actually going to be developed. Right. But first, a little more recent history was that this clause, the 377 clause, was repealed in the Penal Code Amendment Act in 2007. Right. And a new section 377, which criminalizes sex with a human corpse, was instituted in its place. Okay. So this entire section of carnal intercourse against the order of nature with any man, woman, or animal, right, was later on replaced with some form of sex with a human corpse. I suppose that's what you call necrophilia, right? Right.
And I think a lot of us will agree that that's something.
Gross.
Yeah, that's something that no one should allow.
So now after that 2007, actually this entire thing about intercourse against the order of nature of another man actually was removed from history, but instead was reinstated with dead people.
Right. Yeah. But 377A stayed.
377 stayed. So the 377A said, let me just repeat what it is. Any male person who in public or private commits or abets the commission of, or procures or attempts to procure the commission by any male person of any act of gross indecency with another male person shall be punished with imprisonment for a term which may extend to 2 years.
Right.
So that should give you sort of an idea what 377A's context actually is. And of course, this was a clause that's retained and actually in contention for even up to today, right?
Okay.
In our penal code. And just a little bit extra about the history is that in the second reading in the Parliament to amend the Penal Code on 22nd of October 2007, this was during the review for the first repeal. The Senior Minister for State for Law and Home Affairs, Associate Professor Ho Peng Ki, I think that's why he's relevant. If you all don't know, he was one of the ministers for Law and Home Affairs at the point of time, laid down the justification for the retention of Section 377A, stating that Singapore was generally still a conservative society and the majority of its people still found homosexual behavior unacceptable.
Right, and I think this is something that we'll hear again and again.
Yes.
In any conversation regarding 377A, that it's basically a battle between, or not a battle, but a discussion and debate between what is termed the majority conservative society and the minority liberal or progressive society.
That's right.
Quote unquote,
That's
for
right.
everything, because we don't really know anymore what conservative, progressive, and liberals mean.
So because of that, the 377A remained status quo to maintain the country's social cohesion and let the situation evolve naturally. I think that was a statement by the government to allow the situation to evolve naturally.
Yeah, and if I remember this correctly, that proposal to keep the clause sparked a lot of strong comments and protests, because a lot of people in the LGBT community stood up and they basically said that this isn't the country that they want to grow up in. And it attracted a lot of media coverage, especially because Singapore is such an influential country in the world sphere, and a lot of people were paying attention.
And I think at the point of time, society was of a different composition as well, and different views. That's why I think the idea of majority and minority really at the point of time was kind of like different as well. So let me explain so that we can better understand. But there was something called majority views and there was something called minority views, which we'll touch on really shortly. So just to continue, the ministry proposal to keep the clause sparked strong comments and protests from gay supporters, which you say, and attracted wide media coverage. Prior to the second reading of the bill in Parliament, some certain things happened actually, which is there was an open letter sent to the Prime Minister. There was an online petition site called Repeal 377A was set up, and then there was also a corresponding site called Keep 377A as well. So there were really a lot, and I think a lot of activism was actually happening during that before the second hearing and before it was legislated as well.
Was this around the time that Pink Dot also happened?
I'm not too sure. When did Pink Dot begin?
I think they just celebrated their 10-year anniversary. So it would have been around 2008, actually.
Oh, okay.
And I think you can't talk about 377A without talking about Pink Dot and a lot of the other activism groups that have been a big part of Repeal 377A and a lot of these other initiatives. They've been doing a lot of the work and making sure that this is a discussion that doesn't disappear.
Most definitely, yeah. So just to continue, the petition was presented to Parliament by an NMP called Siu Kam Hong. Of course, he was pro-repeal. Head of Parliament sitting on the 22nd of October 2007. And then, of course, his statement was essentially that this discriminated against homosexuals and bisexuals and was an unconstitutional derogation as well of the Constitution. I think what they were talking about is specific to this thing called the equal protection of the law under Article 12-1
of the Constitution.
I think, which is equal rights and protection for all people. All right. So they were saying that this was going contrary. So in a speech in Parliament, he argued that a private consensual act between adults should not be treated as a criminal act, as it did no harm to others, regardless of one's view on homosexuality. Of course, at a point of time, another member of Parliament, Indrani Raja, said that this was, of course, taken out of context.
Right.
So at the point in time, it was quite. We can see really they are really debating this in Parliament and trying to get this 378 and really really getting their views across.
Right.
There was also another NMP who was pro anti-repeal, and her name
So
was,
she wanted to keep 3778.
exactly.
Okay.
So her name was Teo Lee An.
Right.
And she also debated on this to say, and given her points of views in Parliament, it's actually essentially one thing I think was quite this is quite a sticking topic as well.
Right.
Is because both of them, or rather Teo Lee An, actually reported she received hate mails for her stand on homosexual issues.
Oh wow.
And one of these mails was an email that was full of vile and obscene in invective material. Right. So which prompted her to make a police report. So it was quite serious.
Right.
Yeah. The author of the email was someone called Afian Saad, who admitted that he wrote the email in a fit of anger. And but essentially Afian was sued by Teo, but later on, after he apologized, she actually rescinded her.
So I've definitely heard of Alfian Saad.
Yeah.
He's a very influential online personality.
Yes.
and a poet and playwright, especially in making some pretty controversial comments in society. I'll say this: I think regardless of whichever side anyone's on, no one deserves hate, and I think that's also something else about this topic that does make me very, very concerned, which is that basically at the end of the day, people are talking about love. People are talking about what is morally right, either side of the debate. But the moment you introduce hate into the conversation, then
it kind of changes
things.
as
You're
well.
not fighting for the same thing anymore.
Yeah. I suppose as much as there was also hate mail for someone who is pro anti-repeal.
Right.
Siu, which was we earlier covered, Professor Siu was also targeted by some netizens who insinuated that he was promoting a homosexual lifestyle as well. And really, there was some division in society on this matter. There was even something called a group calling itself the Majority. We talked about it earlier.
Oh wow!
Also set up a website to collect signatures calling for the government to retain Section 377A. Essentially, the argument was that repealing this section would force homosexuality on the conservative population who is not ready for homosexuality. And of course, and could lead to calls for same-sex marriages and the trend of adoption by same-sex couples. So this essentially at the point of time where another group of people who feel that their rights and their way of life was going to be disrupted.
Right.
And of course, another people was thinking that we need to progress as society. Right. So really at a point of time, this is the backdrop of 2007.
And I think it's important to note that there are two groups and both of them are very, very opinionated.
Exactly.
Right. So I think something that I've been told a lot is that, it's one group trying to force itself on the other group. I think that misrepresents and mischaracterizes what we are reading, because what we're reading is that it has been a pretty equal debate in terms of people collecting signatures,
exactly,
representing the views. Whichever group is the majority is a different question, but both groups have been vocal,
right?
And both groups have been able to say their piece.
Exactly, and both receiving some form of hate emails,
right? Which is unfortunate all across.
Yeah.
Like, I would hope that if we as Singapore want to set ourselves unique from other countries, that we would do it in every way, right? Being able to have a respectful debate and conversation about this is one of them.
But the question now really is, now that we understand the backdrop, this was actually brought up in 2007,
right.
2008, like you mentioned, Pink Dot was founded as well, or really organized themselves into a group. This conversation actually happened way before as well, right? So this entire thing of 3778, the question begets is, who wrote this into our law?
Yeah, how did it come?
How did it come about?
I'd imagine. So this is what I know, right? I know that being a Commonwealth nation, that we inherited a lot of laws from Commonwealth law.
Yeah.
and British law is basically very much influential on Singapore law, and we've
Mhm.
definitely evolved our own legal system to be very locally applicable.
Yes.
But I suspect, and I know you've done the research on this, but I suspect that basically it has its roots in British law.
Yes, you are actually absolutely right.
Okay, good.
But most specifically, how exactly this wiggled its way through, it was kind of like a complex series of events that actually happened to why it existed in our laws. But the most common thing was this thing called the Straits Settlement Law.
Okay.
And its formation and existence, which created, of course, our Section 377 of the Penal Code.
Right.
Now, what exactly is the Straits Settlement Law? So the Straits Settlement, if you understand, was during the time in 1871, during the colonial administration of the British.
Okay.
Right. It actually the Penal Code was it mirrored the Indian Penal Code and was the primary criminal statute in Singapore.
And this is the same Indian Penal Code that recently had its own repeal.
Yes. In India, of course.
Yeah.
Mm-hmm.
Oh, wow.
Yeah. But before that, let's talk a little bit about the history, just a little bit about the history of the law that we have today. So being Singapore, of course, being in the Commonwealth of Nations,
right?
We took up something called common law, right?
Right.
Of course, for those who are lawyers right now, you can feel free to correct me online and comments, but this is my understanding. It's common law, and the common law, I think, as far as we can go, was this time it called the ecclesiastical. It had this thing called ecclesiastical roots in Britain under this king called Henry VIII.
What is ecclesiastical roots? That sounds like a very biblical thing.
Yes, it is. So I suppose ecclesiastical really borrows its word from the Bible, which says Ecclesiastes, right?
Okay.
Right.
That makes sense.
Yeah. So, and I think that was trying to highlight its most Christian or biblical roots for the law under the King Henry VIII.
Right.
Right. Okay. But just to give you an idea, so there was this thing called, and that's just the origin of the British law, right, that sought to prohibit buggery, and the evolution into Section 377 is found in academic, so these are all the academic papers. But in summary, the British anti-buggery law, for those who don't know buggery, the word buggery actually means sexual intercourse between men.
Oh.
Yeah.
So buggery is a very specific thing.
Exactly. So if anybody calls you a bugger,
oh wow.
Something worth...
I never knew that.
So be careful when you are saying things like, hey, you are a bugger off.
Right. Wow. I never knew that.
Really adds context to the things we say.
Yeah,
right?
the more you know, right?
Yeah, the more you know. So the British anti-buggery law was enacted in 1534, taking over from ecclesiastical law, and the wording used, which included abominable, was taken from things like the Bible, and buggery, which also taken from the word we understand words like sodomy, right, and vice. It really is of like biblical roots that it was formed, and this was how the law was formed. It was formulated in the context of King Henry VIII's break from the papal authority. For those history buffs who know, the King Henry VIII broke from the Catholic Church, and then formed the Anglican Church of what it is.
The Church of England.
Yeah, Church of England, essentially. Right. Yeah, and its purpose was to justify the seizure of the Catholic monasteries, as we said, and the confiscation of other wealthy properties. And so the pretext was the alleged sexual immorality of those in the religious vocation. This was actually how the 377 law was also created, or was to the backdrop of.
Right.
Yeah.
So what you're saying is that the British law that basically inspired a lot of the laws that we're going to be talking about was part of an agenda.
Yes,
and that agenda was to establish the Anglican Church, to justify seizure of Catholic monasteries where they believed that sexual immorality, or very specifically homosexual activity, was happening.
Exactly. So in essence, without this anti-Catholic agenda, right, it seems likely that maybe this law might not have been enacted.
Is that is something that experts say?
Yeah, exactly.
Oh, wow.
Yeah. So I mean, this is a point of view in law. I mean, in history, but you could exactly put why the basis of our common law and some of the laws that we have was stemming from this break off from the Catholic Church, and of course forming the Anglican church that we know, and of course the corresponding laws of the British Empire as well.
Right.
Yeah. So just to carry on, of course, this is the background. This is really historical.
So this is back in the day.
Yeah, back in the day. So now let's talk about something called the Indian Penal Code. All right. So I think this character called Lord Thomas Macaulay. You'll hear it later. We're just talking Lord Thomas, all right? So it's easier for people. Sometimes I'm not very good with English surnames.
Yeah, like, Lord Macaulay sounds like a mouthful.
William Farquhar.
Yes.
Yeah, kind of like tough to handle, right? But anyway, so the British Parliament formed the Indian Law Commission in 1833. The Law Commission in India is an executive body established by an order of the government of India.
Right.
So it's a major function is to work for legal reform within India.
Okay.
At the point of time, India was part of the British Empire. So this was to, of course, bring law and order within India and to have some kind of a legal framework within India.
Okay.
So during this point of time, Lord Thomas was appointed to chair the commission, and he drafted the Indian Penal Code.
Okay.
Essentially took him 23 years of his life to review the commission and the Supreme Court judges in Mumbai, Calcutta, and Madras. These were, of course, popular destinations at the point of time in the British Empire as well.
Probably legal centers as well.
Exactly. So the code was adopted in 1860 and took effect in the 1st of January 1862, so 2 years after its adoption.
So was this an Indian thing or was this a British thing? Like, was Lord Thomas trying to write laws for India, or was he trying to bring in British imposition somewhat?
I suppose the British was already colonizing India,
right,
and they're really imposing their standards, but they also had to bring law and order into India with India's backdrop culture, legal frameworks. So there must be some review of what is acceptable and unacceptable in legal.
I think it's probably important to say that it was trying to bring its version of law and order into India.
Exactly.
Because India probably already had its own law and order.
Exactly.
Its own definition of it.
Right. I haven't researched that part, but I suppose it had maybe a more distributed view about what it is, or maybe it was a monarchy, or maybe it wasn't that, because they didn't exactly have a Supreme Court, maybe?
I think something that I read was that under Hindu law, consensual intercourse between members of the same sex was never an offense. So Section 377 in the British version of the Indian Penal Code was basically something altogether new.
Right. Yeah, I think you're definitely right. So let's go on. Right. Section 377A really was added to the. Okay. So Section 377 was to this backdrop. We talked about the fact that there was the Strait Settlements.
Right.
And then we talked about the Indian Penal Code.
Right.
So this Indian Penal Code was drafted by Lord Thomas, right? It did not reflect any existing Indian laws or custom. It really was just largely a rewrite of the British Royal Commission in 1843.
That we talked about.
Yeah, that we talked about, right?
Yes.
And then adopted, the other drafts included Section 377. But of course, like you mentioned, it is kind of ambiguous.
Right.
Yeah. And I suppose that ambiguity perpetuated to what it is today.
Right. And I think and I think that's something else that we'll see, which is that what initially was meant for social relevance to play a big role has, in essence, codified it into something more permanent than it ought to be.
Right.
The notion that any of this is permanent or has a fixed meaning is completely missing the motivation of this law. This law was meant to be socially applied,
right,
and to have meaning based on social context.
Right. And just to add, so we now know that 377 was actually had its roots in India, and of course the larger root was from British law, right? So Lord Thomas was the one who drafted in 377. But the section 377A which was outrage on decency, right? We talked about gross indecency, was added to the subtitle of unnatural offences in the Strait Settlement in 1938.
Right.
So this was an addition, right? Singapore was a colony, and the Strait Settlement was an administrative unit of the East Indian Company. Okay, and both sections were absorbed unchanged into the Singapore Penal Code from the, of course, from the Strait Settlement, and of course largely from the Indian Penal Code, when the latter was passed by Singapore's Legislative Council on 20th of January 1955.
So let's follow this, right? So it started off with British law when King Henry VIII tried to
divorce himself from the Catholic Church, from the Anglican Church, and then had his own series of laws.
Yeah,
that were convenient.
Which were convenient and targeted at seizing property from Catholic monasteries and institutions.
And of course, legalized certain agendas that King Henry VIII had.
Right. The Indian Penal Code was formed by a British subject who basically was trying to create law and order in India, and he basically just adapted that law for India without any context in India. And then the Strait Settlements, which is an administrative unit of the East India Company, took that law and just put it into the Strait Settlements legal code, and then that was basically absorbed unchanged into the Singapore Penal Code that we currently see today.
Correct. So in 1955, I think that was when Singapore was having its self-governance first time, right? So we sort of like I think we're celebrating. I think it was like self-governance or something.
What the British finally let us
govern ourselves.
Yeah,
and this was written into our laws when we gained self-governance as well. So that's why it became one of the Singapore's Legislative Council. So this is actually the overarching history of the entire 377 and 377A.
Right.
Yeah.
So I think it's important to note at this point, again, two key things. The first is that this law basically is not necessarily a Singaporean law. And that's a question for debate, totally open for debate, but it's not something that was emerged out of a Singaporean context. In fact, it was brought in and still requires adaptation.
I suppose this is a sticking topic because what exactly is a Singaporean and identity?
Sure.
Yeah, we were a colony. They're birthed out to be independent, and with all these things, we were borrowing cultures.
Right, and there's this whole idea of common law as well.
Yeah,
common law basically means that it should be applied regardless of context, that it is common enough that it should be law. And I get that, and I can understand that, but I think it's important to make that distinction because what I hear a lot of times is that this is important to Singapore because it preserves something that is essentially Singaporean.
Right.
And that always is something that I have issues with because it was never just Singaporean. It was inherited from a lot of different contexts.
Of course, yeah. So speaking of debate, guys, if you have a comment about 377A or 377, the history of 377A, even if views about whether we should have it or we should repeal it, I think please leave a comment in the comment section so that we can know about what your views are, and maybe probably we can address it as well. Pretty interesting for a lot of people who are tuning in now. Right. But let's just do a recap for those who are just listening in. So just to keep in the context, right? What exactly is 377A? So let me just do a recap of 377A. All right. So this is how it goes. Any male person who, in public or private, commits or bets the commission of, or procures or attempts to procure the commission by any male person of any act of gross indecency with another male person shall be punished with imprisonment for a term which may extend to 2 years. So what we are debating on today in today's context in 2018 is really this definition of 377A. Now, I think early on we mentioned about this thing called gross indecency. And what exactly do we mean by gross indecency? Actually, there is sort of like a definition of this within the law, actually. And or maybe it could borrow itself in history of how the term gross indecency actually came about. Right. So let's just give you an idea, right? 377A was introduced into the Singapore Penal Code in 1938 to criminalize all other non-penetrative sexual acts between men. So remember we talked about the existence of 377? Right. That's its definition really was to criminalize all intercourse or penetrative acts by criminalizing the penetrative acts in 377,
Yeah.
and 377A was supposed to criminalize for non-penetrative sexual acts between men.
Okay.
So this was how it was actually set out in history. And today we are talking about now we're trying to really define in our legislation what exactly does gross indecency actually constitute. All right. So let me just give you this thing called the Laboche Amendment. I'm not sure whether I'm pronouncing correctly.
Let me Google it.
Right. But anyway, I think once Rovik gets a better understanding of how it is, let me just spell it out. Okay, Labouchere is Labouchere Amendment. All right.
Oh, I never knew this, but there's a website called howtopronounce.com.
Oh, okay. Let's see how it sounds like. Right.
Labouchere.
Labouchere.
Yeah.
Okay,
Labouchere.
sure. Sounds really Frenchy.
Yeah.
Right? Labouchere Amendment. So the term gross indecency used in the statute was based on the wording of the Labouchere Amendment, also known as Section 11 of the Criminal Law Amendment Act in 1885 of the UK.
Okay.
Right? It was not an euphemism for buggery or sodomy, which we now know what buggery means, right? Yeah. Which was already a crime, but rather any other sexual activity between men.
Right. And I can see here that you have the Labouchere Amendment written out. Can I read it?
Yeah, go ahead.
All right. So any male person who, in public or private, commits or is party to the commission of or procures or attempts to procure the commission by any male person of any act of gross indecency shall be guilty of a misdemeanor, and being convicted shall be liable at the discretion of a court to be imprisoned for a term not exceeding 2 years with or without hard labor. So this is the Labouchere Amendment.
Exactly.
It sounds exactly like Section 377.
Exactly. So this is an identical phrasing between this amendment and our current 377A. And of course, the best evidence that the latter was derived from the former, because of course it was from the UK, right?
Right.
So what we could understand really the historical context of what 377A is, if it borrowed from the Labouchere Amendment, was that this was to convict non-penetrative sexual acts between men. So gross indecency, essentially, if I cannot include, I can exclude the fact that it is non-penetrative in nature.
Okay. I feel like we can't do this podcast without talking about what that means. What does non-penetrative gross indecency mean?
All right. So it could imply, for example, in between a man and man, I suppose imaginations could be anal sex as one example.
Right.
Right. So that's penetrative acts as well.
Right.
I think in previous time I read something about an Indian man really penetrating through a cow's nostril. So that's bestiality that also constitutes some action of penetrative act as well.
Right.
Yeah. So I mean, at 377 was actually for both men and women at a point of time.
Right.
And 377 was specific to males, non-penetrative in nature.
Right.
Yeah. So that gives kind of like a context to what we are reading our current 377A. Now, of course, once again, gross indecency, how it's interpreted in our modern context will be largely different, but at least we know the historical setting in which how 377A was founded and borrowed and created, right? So this law was repealed in part of the Sexual Offences Act in 1967 when homosexual acts were decriminalized in England and Wales, with remaining provisions being deleted later. So of course, the England and Wales actually deleted this from their law in 1967. Right. So I guess single section 377A is kind of like descended from the Labouchere Amendment. There is no compelling evidence to support that the legend that lesbians were not included in similar legislations all across the Commonwealth because Queen Victoria refused to believe that women were capable of such behavior.
Oh, wow. So
and that's why.
So this is a rumor that.
This is a saying of why 377A was specifically about men. Why is it not about women? It's because at the point of time, Queen Victoria didn't believe women were capable of such acts.
That's a myth, basically.
That could be a myth. Not sure. It could be a myth, right? It could be a legend.
Right. Oh, and over here we have actual examples of what gross indecency could include. So content warning. If there are young kids listening to this, it's a good time to close your ears or maybe ask your parents if you should be listening. But it includes mutual masturbation,
right,
genital contact, or even lewd behavior without direct physical contact. So performing such acts in private does not constitute a defense. So that means even if no one saw you, it is still criminal.
Illegal.
And wow. So that's very interesting.
Right.
And what I'm seeing here is that there is not, nor has there ever been any law in Singapore equally specific to non-penetrative lesbian sex. So I think that's something else that has been a big part of this conversation, which is, you know, if you are basically trying to police or moralize a certain way of life, specifically the homosexual way of life, then why is it specifically against men, right? So I think that's a very interesting space for debate. It doesn't really hit the main point, which is why is that law there in the first place. I think answering that question will be able to give us a better starting point for any kind of discussion rather than anything else.
Which begs the question, so if, for example, I'm not very sure of the law, but if a lesbian couple were to do a lewd act in public or in private and they got caught, would they be criminalized?
I think there are other laws in the Singapore Penal Code that will catch that. And that's the biggest thing, right? Like the Singapore legal system is very, very comprehensive in that aspect. So don't worry. If you do something...
not worrying, bro.
Yeah. The government will probably have something on you.
And of course, to add some history or so of how this topic was being debated, just to name probably a few about the brave people, or rather some of the individuals who were brave enough to challenge this repeal of the 377A. I think there were things like, for example, Tan Eng Hong versus the Attorney General in 24 September 2010. About challenging the constitution of Section 377A. Right. At the point of time, the lawyer was M. Ravi. I think M. Ravi is
a very, very notorious guy. Yeah, it's probably worth looking into him if you've never heard of him. But M. Ravi is a very prolific person in Singapore.
Right. I wouldn't say notorious. I would say maybe prolific or very well known for his activism as well. Right. And I think he was acting on behalf of Tan Eng Hong, who was charged for allegedly having oral sex with another consenting adult male in a locked cubicle for public toilet. Yeah, and so of course this is once again another appeal. I think this is another area in which was challenged in court at that point in time. Unfortunately, the law were decided against him at the point of time, upholding the law at this point of time.
I mean, it was thrown out of court, and the reason for it was, quote unquote, citing a lack of a real controversy for the court to deal with. And I think that the key issue here was that it was then said that according to the Supreme Court of Judicature Act of Singapore Rules of Court, that only if the case was considered not frivolous, then it could be argued. But then the Court of Appeal said, actually, that's not so true, because this is a non-frivolous ruling. And 377A did affect the lives of not an insignificant portion of Singaporeans. So the key recognition here is that the court has basically said that the community that is affected by 377A is a significant and worth its place in court, right? And I think that's a very significant thing, because if anything else, that is the court recognizing that these people exist, and have an argument.
Of course. I think to look at it also another way is that I think there was another case in which they believed that the law was a mere or rather the courts were a mere tool,
Right.
or rather to exact the law that's legislated.
Right.
Yeah.
And this is something that we know about the way good governance works, right? You have three parts of government. You have the legislation, legislative, executive, and judicial.
Right.
Right. And all three need to work in tandem.
Right.
But the judicial only can enforce the laws created by the legislature.
Exactly.
Right.
So because the legislative has not repealed or has not done further or amendments, the judicial had to actually execute the law.
Right.
In fact, just to uphold it.
Right. And
so I suppose this is a very sticky situation as well. It's very, although it's easy to understand, I suppose,
right.
but something that is worth noting as well, whether you decide to fight in the courts or you decide to fight for reforms within the legislation.
Right. And I think this is something that we'll see again with the next case, which is Ling Meng Swan.
Right.
And another versus the Attorney General. And basically in this case, a constitutional challenge was again filed in 2012 on behalf of Ling Meng Swan and Kenneth Chi, a gay couple of 15 years, by attorney Peter Low.
Right.
And basically what happened was that Justice Quentin Low ruled the same thing, basically saying that this is a case that needs to be basically he has to enforce the law, and any kind of challenge has to be done in Parliament, right? What is interesting about this is that they appealed to the Court of Appeal, and they tried to get two highly esteemed lawyers, not from Singapore. So one of them was a British lawyer, and a former Attorney General for England and Wales, Lord Peter Henry Goldsmith. And Goldsmith had agreed to take the case without pay.
Wow.
Right? But they were disallowed because Justice Raja believed that the legal issues were arguable by domestic lawyers, which is preferred by Singapore.
Okay.
And I get that.
Okay.
Right? I think that's a very valid consideration. But I think what was attempted here was to bring in the kind of argumentation that has been used in the UK in Singapore.
Right.
So the Court of Appeal rejected the challenge, ending the case. But the key argument that was made was that the challenge didn't stand because it was consistent with Article 9, as Article 9 is meant to protect against unlawful imprisonment, and that it is consistent with Article 12, because Article 12 only mentions religion, race, and place of birth. So discrimination on gender, sexual orientation, or sex is not necessarily the same kind of argument.
Sure. And I think we talked about the fact that we separated the judicial as well as the legislative. So as in all judgments before, the court held that any legal remedy would have to come through an act of Parliament.
Right. And so that actually makes it really, really interesting why what happened with Professor Tommy Koh, right? So exactly what happened was that after India basically scrapped its British colonial era legislation, which we read about in the Indian Penal Code, Tommy Koh is ambassador at large at the Ministry of Foreign Affairs, made the comment saying, in response to someone's post, he said, "I would encourage our gay community to bring a class action to challenge the constitutionality of Section 3778. And someone basically replied, this person called Edward Tay, he said, "Professor, hasn't that angle been disposed of by Ling Meng Swan," which is the case that we just talked about. And Tommy Koh very, very sheepishly says, try again.
Wow. But so you know what? Let's maybe look at the context of today. Now we know the history. Now we know the battle for the repeal or the stay of 377A. Let's have sort of like a understanding of what exactly is going on with the minds and hearts of the people in today's context. Today is 2018.
So what is the majority, right?
So there was a Straits Times article recently, right, that indicated this very interesting title called 55% of Singapore residents support Section 377A.
So they support IPOS, keeping it.
Yeah, support IPOS survey. So what that means is that the online survey by IPOS Public Affairs of course, an independent market research company, was conducted over a period of 4 days from July to August in 2018 to understand the social attitudes towards same-sex marriage, same-sex relationship, sorry, not marriage.
Right.
I correct myself, towards same-sex relationship. And this survey had about 750 Singaporean citizens and permanent residents. But if you say that 55% of Singapore residents support Section 377A, we mean also that 45 people don't, 45% of people. So when asked the extent of these 750 Singaporeans, whether they support or oppose 377A, of course, we said that 55% supported it, and while 12% actually said they opposed it.
Right.
Yeah.
So that means the remainder didn't have a strong opinion.
Right. So the sentiment varied according to gender, with males more likely to strongly support the law than females. And Singapore residents aged between 15 to 24 were more likely to oppose the law. So the young ones were more likely to oppose the law, while residents aged 55 to 65 were more likely to support it.
Right.
So it's still, I would say that it was pretty much maybe split between age groups as well.
Right.
Yeah.
And I think it's a bit dangerous to theorize just based on this data, because we don't know the context, we don't know exactly what was happening. But it is not something that is completely unfamiliar. So even with Professor Tomiko's recent challenge, what happened was that there were two petitions that were started concurrently. The first one to keep 377A and the other one to repeal it. And the numbers basically show that there were more people in support again of keeping 377A.
Of course.
So these are not unsurprising numbers. It is worth talking about probably in a different session, or even in your own communities or groups, whether those things are quote unquote morally questionable. That's not what we're trying to do here today. We're just trying to understand it.
Interesting to note that 33% of Singapore residents, when they were posed this specific question, right, agreed with the statement, "I am more accepting of same-sex relationships than I was 5 years ago," while 35% disagreed. So we seem to also have people who would say that, in the past they disagree, but now they actually agree.
Right.
Some people said that, of course, they don't. But I think we are seeing really quite a distinct line, right? If you're saying that 55 and 45, or maybe some have abstained from making these comments, we're seeing a growing discussion as well in today's online as well, in the public sphere as well. People are really talking about 377A, and really, I think the history of 377A is, I think, part and parcel of our identity as well.
To be Singaporean means to talk about every aspect of our nation, and it includes the people who are from the LGBT community, who do have a valid argument in making that claim. I think the key thing about all of this is that we recognize a number of things. The first is that the law itself doesn't have any intrinsic meaning by itself. It is actually more symbolic of things that have been passed on, and it is basically something that people it's designed for social application, right? That's something that we've seen from the Indian Penal Code, from the inheritance, from British law, and I think that's important because we need to have a conversation about all of this, right? I think the second thing about it that I'm learning today is that these conversations are good, right? So regardless of your stance on it, it is important to still value our ability to have this conversation.
Sure.
Right? We need to value the fact that we are able to decide what it means. And I think Minister Shanmugam basically said that. He said it is up to the Singapore society to decide, but the majority of Singaporeans were currently opposed to any change of the law. But the key thing is that it's up to us to decide. And the only way to make that decision is if we have open communication in good faith.
Right. Right. And continue the debate, of course, without hate emails.
Yeah.
And
Yeah.
without both sides throwing hate all around.
Right.
And we, of course, have a very good discussion about how we should progress society.
Exactly. I mean, as of September 17th, whenever you guys are listening to this, as of September 17th, 2018, there is currently a challenge already being filed with the High Court, and that is by this person called Johnson Ong. He's a DJ Big Kid, and this was after the ruling in India where they repeal their version of 377A, and after Professor Tommy Koh's challenge. So this is a conversation in progress. There is no there's no necessary endpoint to it, and it's something that we'll have to continue talking about. I think for a while to come.
Definitely.
Yeah.
All right. I think that's all we have for today.
Yes.
I've just seen the 1 hour clock as well.
Yes.
Thank you for joining us today talking about 377A. I hope that you guys understood what exactly you are repealing or you're supporting, but definitely this adds context to what you are going to be doing next time or having a conversation with other people.
Right. I want to reinforce, have a conversation, talk about it, debate about it, develop an opinion about it, because I think that's what makes us good citizens.
Okay, definitely. So thank you, everybody. My name is Willie, and
I'm Rovik.
All right, we'll see you next time on SG Explain. Good night.
Cheers.